A very good evening and welcome to today's Ekatva webinar session. This is Ravi Mudaliar from Ekatva and our today's topic is Understanding RERA Litigation and Complaint Mechanism. To lead this discussion, we are joined by Advocate and Company Secretary Lokesh Shah. Mr. Shah is a leading RERA and real estate law specialist based in Ahmedabad with over 7 years of experience in real estate and corporate legal matters. His core areas of expertise include RERA registration and litigation, real estate documentation, FEMA and FDI structuring, due diligence, corporate compliance, and the practical interpretation of RERA orders. He has been recognized by ICSI, WIRC, and is the author of India's first real-time updated RERA ebook. He is also an active speaker and faculty member and has addressed forums of ICAI, ICSI, CRED AI, Chartered Accountant Study Circle, the Income Tax Bar Association, and the Sivalik Institute of Real Estate. We are honored to have him with us today and look forward to his valuable insights. Over to you, Lokesh.
Thank you, Ravi bhai. Good evening, everyone. On the topic directly, we will deal today with the litigation aspects under the RERA. Let me just share my. It is visible, right?
Yes, Lokesh bhai.
Okay. So today we'll go through the litigation aspects under the RERA Act 2016. So basically, as we know, RERA deals with the transactions or the governs the transactions between the promoters and builders. So for let's say for securities law, let's say stock market, there is a specific authority like a SEBI. So same way for real estate transactions arising between the builders and buyers, the government came out with the new act called RERA Act 2016 and it came into effect from 1st May 2017. And under that, a specific authority has been framed with an objective to regulate the transactions between the builders and buyers. And the objective of the authority is to bring the transparency in the transactions as well as to regulate and adjudicate the disputes arising between the builders and buyers. So, considering under the RERA Act 2017, there has been certain powers and there's an authority has been formed and certain powers and duties has been entrusted upon the authority as well as the builder and as well as the buyer, which needs to be enforced by the RERA authority. And in case of disputes, the authority can adjudicate the disputes and decide the matter just like a civil court. So basically, what is the basic structure is when a buyer has a dispute against the builder, let's say society has a dispute against the builder or a single buyer has a dispute against the builder, he can go file a complaint before the RERA authority through the RERA authority's portal, online or offline mode, and the authority will ask the builder to file a reply on that and will hear both the parties and will decide the matter. Once the RERA authority decides that matter, and if you are not satisfied with the order either of the party, either of the party can file an appeal before the Gujarat RERA Appellate Tribunal. The time period is 60 working days. Within 60 working days, you can file an appeal before the Gujarat RERA Appellate Tribunal. And even if you are not satisfied with the order of the Appellate Tribunal also, then you can directly file an appeal to the High Court and then a Supreme Court. So that's how the whole mechanism works. So now it's ultimately the either it's a RERA authority and then RERA Appellate Tribunal and then High Court and then Supreme Court. And under the Act, now there is no powers to the civil court to decide the matter arising between the builders and buyers. So everybody has to compulsorily move to the RERA authority only. That is the basic structure. So once your matter is decided by the RERA, you can file a review if there's an apparent mistake on the order of the itself. If you are agreed by the order, then you can file an appeal and within 60 working days and then further appeal to the High Court within 60 working days. So now who can file a complaint? So any aggrieved person can file a complaint against whom? Against any promoter or an allottee or an agent. So not only the buyer can file a complaint against the builder, a builder can also file a complaint against the buyer. So if your buyer is not making payment as per agreed terms, or is not coming forward to execute some documents or cancel their documents or whatever reason, then a builder can also file a complaint against the allottee, as well as the allottee if having any issues like society handover is not happening, or the units are cancelled unilaterally by the promoter, or the units are cancelled but amounts are not paid yet by the promoter to the allottee. All such scenarios which we have covered in detail in the further deliberation are, in such scenarios allottees can file a complaint against the builders before the RERA authority. And allottee has been specifically defined under the Act, which includes the person who has even subsequently acquired that unit through sale, transfer or otherwise. So let's say while construction or while the property was under construction, I had purchased from the builder, but later on before executing sale deed in my name, I directly sold it to Mr. X. Then Mr. X is also governed as an allottee under this Act, and he can even file a complaint before the RERA authority for any disputes against the builder or the facilities not provided by the builder. There is one landmark judgment called Lavasa Corporation's Brookview Project, Lavasa City in Devas, Pune. In this case, the Bombay High Court has held that even long-term lease is covered under the RERA. So, under the definition of the real estate project given under the Act, only the sale transactions are covered. But in this particular case, the Bombay High Court has held that long-term lease are as good as sale. So, any property transaction which has been executed on a long-term lease, like in the GIFT City, there's a lease transaction happening for 99 years. Same way, the units constructed by the planning authorities like AMC, ODA, Gujarat Housing Board, all are given on a lease basis only. So, those transactions or those builder-buyer transactions are also covered under the RERA only, and those public authorities are also required to comply with the RERA rules, as well as the buyers or allottees in those projects can also file complaint against the public authorities before the RERA authority. So there are, under the RERA there are two judicial mechanisms. First is the authority and second is the adjudicating officer. So under the RERA there are mainly 4 sections under which an allottees are given their relief. Section 12, 14, 18 and 19. Under this relief, along with the all other reliefs, there are an additional relief of claiming the compensation. So if you are claiming any compensation for any reasons or any provisions which has been provided under the Act, you need to file your complaint before the adjudicating officer in a Form B by paying 1000 rupees in online or offline mode. Whereas for any other issues like unilateral cancellation or a delayed period interest or a delayed possession or a seeking stay or a seeking cancellation of the RERA or whatever it is, apart from a compensation, if there is any other prayer you are seeking, then that complaint is required to file before the Gujarat RERA authority under the Form A by paying 1000 rupees fees in an online or offline manner. So you can file your complaint by logging into the Gujarat RERA portal, that's gujrera.gujarat.gov.in, and that portal you can directly file your complaint and pay 1000 rupees charge and upload all the documents related to your complaint. You just need to prepare a statement of facts in a brief, attach all your evidences along that, upload it on a portal and pay the 1000 rupees fees and your complaint is registered. It's very simple. So you just have to create your user and upload your documents. That's the whole process is. And the link of the website is gujrera.gujarat.gov.in. If you are not comfortable with going online, you can even file your complaint offline by just preparing a DD in the name of Gujarat Real Estate Regulatory Authority of 1000 rupees. You can and preparing all your documents in the physical form and submitting it to the RERA authority directly. So while filing a complaint, you need to keep certain aspects in your mind. The complaint can be filed only against the registered real estate projects or projects which are registrable under the Act. So those projects which are outside the town planning area or are exempted from the registration under the Act are not, against that complaint cannot be filed before the RERA authority. a group complaint, like many of the allottees of a single projects, can file a joint complaint for the similar issues. In that cases, you can claim the formation of association of allottees or handover of the society, or society formation is not done by the builder. Therefore, all that cases, various members can jointly file a complaint. Complaint related to common area amenities and the issues in that can also be filed by the jointly by the various members of the society. And society can also file a complaint on behalf of all the members on a single complaint. But if you are seeking relief for individual units, like C404 has some issue, E101 has some issue, B202 has some issues. In such individual unit cases, you have to individually file the complaint and pay 1,000 rupees separately for a complaint, and that complaint will be adjudicated separately. So if the common issues, you can file a commonly. If it's an individual unit related to issue, you have to file individually. Now, once you file a complaint, the promoter will be able to see that complaint in their login dashboard, and even download all the documents uploaded by the complainant, and need to file the reply on that by using that window itself, or can directly invert their reply to the RERA authority. And in case the complaint is filed in an offline manner, then you need to send the complaint copy by registered AD to the promoter. So that's how this whole scenario works. If you are filing offline, then you need to serve the copy through RPAD. If you are filing online and all the documents are uploaded online, promoter can very well look into their login and can go to the documents and complete it. So once the complaints are received, RERA authority scrutinizes it, examines it, and raises if any query. You need to sort out the query raised or additional documents sought by the RERA authority. Once you do the same, RERA authority issues notice to the respondent party. Respondent parties are required to file the reply on that. On that reply, the complainant need to file the rejoinder. Further, both the parties can file the written arguments in support of their claims. And after that, RERA authority hears the matter on the merit and passes the order. So authority has all the power, like a civil court, to adjudicate your complaint. So RERA authority can call for the evidences, RERA authority can seek for the witnesses, RERA authority can ask the complainant or respondent to appoint any site engineer and get the report done and provide that site visit report, or can appoint court commission to have the site visit report. All by doing all such adjudication proceedings or investigation proceedings, RERA authority can decide and pass the orders. Once the order is passed, RERA authority also has a jurisdiction like a civil court, where the RERA authority can rectify its own order or can review its own order. And if the order is passed but is not complied by the party against whom this order has been passed, then the complainant can even file an execution petition, and the RERA authority has all the powers to get that order executed by various means. RERA authority has all the powers like a civil court to conduct inquiries and investigations, to call for evidences, to issue interim orders, to impose the penalties, or to do whatever needed to decide that complaint. The allottees has a right to file an appeal against that order, and now civil court, after the enactment of this act, has no jurisdiction to decide any disputes arising between the buyers and builders. So normally under the act, there are some specific sections under which the remedies have been provided to the property buyers, and these are the major scenarios for which the complaints are normally filed by various home buyers. The first is cancellation of allotment of the units, where builder unilaterally or one-sided without any sufficient reason cancels the unit of the buyer. Then the home buyer can file a complaint before the RERA authority against that unit, and can seek the restoration of unit booking and can seek the possession of the unit under section 11 subsection 5. Under section 12, if any person due to false or incorrect statement or information provided by the builder in advertisement, prospectus or brochures or in a sample house suffers any loss or damage, then he can file a complaint before the RERA authority to direct the builder to make or provide the services which has been committed into the brochure or as per the sample house. So if we see practically in the brochures, builders may write a disclaimer stating that this is just for the visual purpose and is not legally binding document. But whereas as per the statutory provisions, brochure is a legal document and all the facilities and amenities mentioned in the same, the builder is liable to provide the same as shown as in the brochure itself. So if the builder does not provide any amenities as committed by him in the brochure, then an allottee or home buyers or society can file a complaint for the same and seek the direction before the RERA authority to direct them to provide the same. Then section 14.3 provides a 5 years defect warranty or a structural defect warranty or poor workmanship defect warranty to the property buyers. So under this section, if there is any issue arising into the unit or the common area of the project, which is due to the poor workmanship or a structural defect in the work done by the builder, then the association or individual unit holder need to intimate the same to the builder, and the builder is required to repair the same within 30 days without any charges. If the builder does not repair the same or removes that defect, the buyer can go to the RERA authority, can file a complaint, and RERA authority will direct the builder to remove that defects. Even for that defects and everything, you can claim a compensation also in addition to the removal of the defect. Then under section 18.1, if the builder fails to give you the possession of the unit within the agreed timeline as per the agreement for sale, then as a home buyer, you has a right to decide whether you wish to continue in the project or you want to withdraw from the project. If you wish to continue in the project, then you can claim the interest for all the amounts paid for the delayed period of a possession. And if you decide to withdraw from the project, then the promoter is liable to make you refund of the whole amount along with the interest. So it's a allottee's choice. If you wish to claim the delayed period interest and continue in the project, you can claim your prayers accordingly. Or if you want the return of your money along with the interest, then you will have to pay accordingly. Apart from that, even after giving a possession of the units or a society handover, if tomorrow there comes out any issue in the title of the land of the project, then the allottees or the societies can claim compensation from the promoter as well as return their units. Apart from that, if there is any other obligation which has been agreed by the promoter in your agreement for sale, but that has not been fulfilled by the builder, then you can claim a compensation for that also by filing a complaint in a Form B before the adjudicating officer. Apart from that, the builder is required to execute a registered agreement for sale and also mention all the websites, RERA number before everything into their notice boards or advertisements or prospectus issued. So if the builder is not mentioned that, then you can even file a complaint for that too. The builder is required to obtain the completion certificate on a completion of the work, as well as is required to maintain all the essential services like water, common electricity, borage, everything. And if he does so, or if he does so but is not handing over the society in a timely manner to the society members, even after repeated reminders, then the society members on behalf of the society can file a joint complaint before the RERA authority and sought for the formation of the association as well as the handing over of the society from the builder to the home buyers association. And even if the builder is not transferring the maintenance deposits amounts to the home buyers in a society account, then also complaint can be filed before the RERA authority seeking the transfer of the funds. If the promoter has cancelled your unit against the agreed terms of the agreement, then also you can go to the RERA. As per the section 13(1) of the Act, the promoter is required to execute registered agreement for sale before accepting more than 10% of the unit consideration. So let's say your agreement value is 50 lakh rupees and the builder has already taken a 5 lakh rupees. Then before accepting more than 5 lakh rupees, the builder is required to execute the registered agreement for sale, not notarized, registered agreement for sale. And if he does not execute it, then also the members can go to RERA and ask the direction seeking the execution of registered agreement for sale to secure their rights. Apart from that, if the builder makes any changes in the plans or layouts of the project without the consent of the members, then also members can go before the RERA authority and can file the complaint. So there are many scenarios, out of which these are the general scenarios for which complaints are filed. But depending on a case-to-case basis, if there is any specific scenario, then definitely you can file your complaint before the RERA authority, and RERA authority can exercise its jurisdiction and can decide the matter. Under section 56 of the Act, any person who is filing the complaint can by himself represent his complaint. It's not necessary to have the advocate to file this complaint or represent this complaint. However, under the Act, an advocate or a chartered accountant in practice or a cost accountant in practice or a company secretary in practice can represent the cases on behalf of the parties before the RERA authority as well as the appellate tribunal. So if you are not by your own self comfortable, you can hire any advocate or a CSCS or a CM in a practice to file your complaint and represent before the RERA authority. Under section 79, now the civil court has no jurisdiction to entertain any suits which are related to contravention of the provisions of the RERA. So now once your project is RERA registered, and after that if there are any disputes between the builders and home buyers, then you ultimately the suit or the complaint should be filed before the RERA authority only. Civil court has no jurisdiction to entertain any suits arising for the violation of the RERA Act. Under section 88, which is very important, this law states that the provision of these acts are in addition to and not in derogation to provisions of any other law timing in force. So provisions of the RERA are having an overriding effect over the provisions of the any other act, but except IBC. So provisions of the RERA Act are in addition to and not in derogation of the provisions of any other law for the timing in force. So you can seek any remedy available under any other law in addition to the remedies provided under the RERA Act. And provisions of this Act has an overriding effect against the provisions of the any other law. So let's say Limitation Act provides for the 3 years of timeline for filing a complaint. But as the RERA Act has an overriding effect, even if that limitation timeline of 3 years has already been passed, RERA has no limit time period prescribed for filing a complaint except for the section 14(3) complaints. You can file your complaint even after the expiry of 3 years. Only for the structural workmanship defect or poor workmanship related issues can be raised within 5 years from the date of the possession. Apart from that, there is no time limit prescribed under the Act for filing any type of complaints except the structural defect or workmanship defect kind of a complaints. So you can even file that after whatever time has passed, but from the time it has arrived, you should file it as soon as possible before the RERA. RERA very vast powers, as good as the civil court. to impose penalty or interest or to issue the notices or call for the evidences. RERA authority is guided by the principles of natural justice, and hence even if the matter is simply clear cut on the paper, the RERA authority has to issue the notice and provide the other party the chance of representing him or herself. From that, whenever once a RERA authority passes an order and the promoter wants to go for an appeal, then the promoter is required to pre-deposit the amount of interest or refund ordered by the RERA authority, and then only the appellate tribunal can admit the appeal and can hear. But that mandatory provision is only for the promoters, so that in deserving cases promoters do not file the appeal, and to prevent the forced or forged appeals, this provision is in force. But in case if the allottee wants to go for an appeal, there is no such pre-deposit mandatory provisions is there. So in case any penalty has been levied on the promoter is required to at least deposit 30% amount of the penalty. But in case any refund or interest has been ordered in favor of the allottee, then in that case the promoter is first required to pre-deposit that 100% amount before the RERA appellate tribunal, and then only the appeal can be decided upon or heard by the appellate tribunal. So under section 43, there is a provision which states that the state shall establish the real estate appellate tribunal, and an appeal can be filed within 60 days of the receipt of the order, and the 60 days period is 60 working days has to be counted upon. And once that order is passed, after that, even if you are not satisfied, you can go to the High Court directly within 60 working days. The appeals memo format has already been prescribed by the appellate tribunal, which contains the particulars of appellants and respondents, copy of the impugned order, grounds of appeal, statement of facts, and relief sought, if interim relief sought, if any, verification clause, and relevant attachments. You have to prepare that appeal memo, got it notarized, and submit it with the appellate tribunal with 1000 rupees fees. So these are the basic provisions which governs the basic structure of the RERA authority as well as the RERA tribunal, as well as the various criteria under which the complaints are filed by the RERA before the RERA authority. And now we will move to some important judgments and scenarios which has been over and period of time has been prescribed by the RERA authority, has been decided, and which are treated as precedents by the RERA authority. So these four first judgments, Manoj Votar versus Sea Princess Reality, Sano Resource and Ranveer Sharma and others, Mohit Melwani versus AA Estate, and Bright Sky Heights Developers versus Rajendra Eknath Pawar. In all these four cases, the judgment was that if you are claiming for a compensation, then you have to file your complaint before the adjudicating officer. And if there is any issue apart from that, the compensation, that is, let's say interest or a refund with the interest or any other direction, then the complaint must be compulsorily filed before the RERA authority only. Adjudicating officer has no power to grant the refund of the interest or refund of the amounts paid. So while filing the complaint, before filing it, we have to see where is the jurisdiction for whatever prayers we are seeking, and accordingly we need to file our complaint. Otherwise, if the court do not has a jurisdiction and if we file our complaint, then our complaint is gonna rejected, and that will lead to waste of our times and resources, and we'll have to again start from the zero. So that is one important factor which needs to be considered. Then there is one latest judgment for the society Kasalma Cooperative Housing Society Limited. This was also covered in the newspaper. In this complaint, the complainant society had sought a proportional maintenance for the unsold units from the builder. So what happens that even if the whole project is completed, BU is received and construction is completed, possessions are also granted, but there remains some unsold units which are yet belongs to the builder only. Now builder charges the maintenance to the various society members, but he does not contribute his part of maintenance for the unsold units. So in particular this case, the society went before the RERA authority and sought direction against the builder, seeking that he shall also contribute the proportionate charges of maintenance amounts of unsold units to the maintenance fund. The authority, after the due deliberation on the matter, adjudicated that the builder is liable to pay the similar maintenance charges as paid by the society holders, unit holders in the society, and directed the builder to pay that amount within 45 days to the society. Even the promoter has gone for the review against that order, and that review has also been rejected by the RERA authority. Now the promoter till date has not filed appeal against that, but if they file so, otherwise this order as on date yet as appeal is not filed is final. Then there is an order in the matter of Eden G2R Cooperative Society. What has happened is the builder, that is Godrej Group, has provided accounts of the society which contains for the accounts of the A to G block, out of which there are two blocks which they are registered, and rest of the blocks were already completed and BU was obtained before the RERA came into force. So those part of the blocks are not required to be registered with the RERA authority. But the society was formed in 2020. Society handover was done by in 2020. But as the accounts are already clubbed, the issues in the society accounts raised by the society members were not considered by the RERA authority, stating that as the complaint contains the part of the expenses of the project which is already completed before the BU and is not required to be registered before the RERA, RERA authority cannot together decide both the parts, and hence as on date the complaint cannot be decided upon. So if you have some such kind of a project where certain part was already completed before the RERA and certain part of project has been completed after the RERA, then for the part of the project which is registered before the RERA, for that part only you can go before the RERA authority and not for the whole part. Then there's another case in the case project ROE Elysium located in the Bhopal. Manish and Nimmak and others were the Siddhi developers and Somsundar Vikas Tower Mandal. In this case also the promoter was not forming the society and was not transferring the society maintenance funds taken over by them. In that scenario, the society went before the RERA authority and asked them to direct the promoter to form the society. The promoter came before the RERA authority and raised the contention that it is not possible to form an association of allottees by way of society, as on that land there already exists an old society. The RERA directed that the duty of closing that or suspending that old society and forming a new society lies upon the promoter, and the promoter is required to form the society and transfer the funds to the society members within 3 months. So even in such cases where the builders are not forming the society or not transferring the maintenance deposit fund, RERA has issued directly directions to them to form that society and transfer all the funds within timeline manner. In this Carmel Cooperative Society versus Godrej Properties case, the promoter as executed maintenance and management for a considerable time and then handed over the maintenance and management to the society along with the accounts for the same. The society audited that accounts through a chartered accountant and found that there are many discrepancies in the accounts provided, like many amounts are double charged, many wrong billings are done, many amounts are excessively charged. All such kind of issues were identified by the auditors. Society filed a complaint before the RERA authority to claim that amounts, and the RERA authority considered certain amounts and did not consider certain amounts. So here the point is, when a builder hands over to the society, hands over your accounts, and you get it audited and found some discrepancies, then for that discrepancy things or claiming that amounts also, you can go before the RERA authority and claim your amounts. This matter is currently pending before the appellate tribunal, but RERA authority has taken a view that RERA authority has a jurisdiction to go into the books of accounts also and direct the promoters to provide the correct books of accounts as well as refund the excess amounts charged. In this case of Paresh Goel versus Sunit Choksi, the promoter had forfeited, the unit was booked by Paresh Bhai Goel in one of the projects. That later on that Paresh Bhai Goel did not make the payment as per the agreed terms. So builder as per the agreed term forfeited 10% of the unit value and then asked them to take the refund of the remaining amount. So promoter forfeited 1,50,000 rupees, that is 6.28% of the total unit value, and refunded the remaining amount, that is 3,11,000 rupees. But the buyer, not satisfied with that order, filed a complaint before the RERA authority, sought the refund of the whole amount, and prayed before the RERA authority to see that no cancellation amount is charged. But the RERA authority relied upon one Supreme Court judgment recently passed by the Supreme Court in the matter of Godrej Properties, wherein it stated that the promoter can charge 10% of the amounts maximum as any cancellation charges, not more than that. And the amount charged in this case was 6.28% only. So promoter is very well entitled to charge that amount and refund the remaining amount. And hence there was a complaint has been dismissed by the RERA authority, and the promoter was directed only to refund the remaining amount to the complainant. This is a very landmark judgment given by the Honorable Supreme Court of India, and this judgment is oftenly referred to by the various matters or the advocates while having the matters before the RERA authority. In this matter, what has been importantly confirmed by the Supreme Court is a contract or a term thereof which is substantively unfair, if such contract or the term thereof is in itself harsh, oppressive or unconscionable to one of the parties. The Honorable High Court or a court strongly reaffirmed that builders cannot hide behind one-sided buyer agreements and incorporating one-sided clauses, which amounts to unfair trade practice under Section 2R of the Consumer Protection Act. Such terms were held wholly one-sided, unfair, unreasonable, and thus not binding. So what happens that whatever papers you have signed with the builder, but if the terms of that contracts are one-sided or are such clauses which are written but are unfair to the home buyers, then you are, being a home buyer, you are not bound to follow that terms. That terms are not binding to the parties, and you can very well raise dispute on that terms too before the appropriate tribunal or courts or the authorities, which is a very much what you say a required thing, because in real estate nobody reads the documents. The builder just calls you, their advocates drafts that report or documents are already ready, you just go and sign that contract. But if there are terms which are against your interest or which are one-sided or which are inferior to your rights, then that terms are not binding. Even if you have signed it, you can raise dispute on that before the various courts by relying upon these judgments. In this case of Jyoti Vinay Patarkar and Vivai Vinay Patarkar, the dispute was related to rate of interest, whereas it was held that when rate of interest payable by builder to home buyer should be equivalent to the rate of interest payable by the home buyer to the builder. So let's say when a home buyer or a property buyer makes a delay payment, the builder charges 18% rate of interest. Then if the builder delays the possession of the unit, so if the builder fails to provide you the possession of the unit within agreed timeline, then the builder is also required to make you the payment of the interest at the rate of 18% only. There cannot be term where the home buyer is liable to make a payment of 18%, but in case of delay, builder pays only 5%. So in this case, this was upheld that the rate of interest should be equal, and as the home buyer was liable to make the payment of interest at the 18%, builder was also directed to make the payment at the interest at the rate of 18%. In this case of Ratul Lahiri versus Tata Housing Development Company Limited, a villa was booked by the allottee, but agreement for sale was not executed. He had already paid amounts of 59.73 lakh and possession was submitted in the year 2018, but was not paid. Possession was not given. The project was already late and even not ready by year 2022. The developer argued that as per section 18, agreement for sale is not executed, and the term mentioned under section 18 is if you fail to give possession by the term as per agreed in the agreement for sale. As in our case, agreement for sale itself is not executed, the RERA authority cannot grant the interest. Whereas the court held that even if the agreement for sale is not executed, but there are other papers, supporting documents, which shows that you had committed possession in a year 2018. And as you have failed to provide the possession as you had committed, you are liable to make the payment of interest as per section 18 of RERA even after the agreement for sale is not executed. So in that loophole that builder does not execute agreement for sale, so that there does not arises any legal liability, that has also been plugged in by the courts or authority by passing such judgment in this matter. In this case where Alok Kumar versus Golden Peacock Residency, the consumer, this judgment has been passed by NCDRC, that's the National Consumer Dispute Resolution Commission, wherein it has been stated that complainant cannot be made to wait indefinitely for possession of the unit, as the construction is yet to be completed even after a period of more than 6 years has elapsed from the date of booking. So what happens that, let's say the promoter executes the agreement for sale with you, but he does not specifically mentions any date for the possession in that. They may mention it very vaguely, like whenever we will complete the work, we will obtain the occupancy certificate and then the possession will be provided. They does not mention any time like 3 year, 4 year, 5 year, 6 year or any particular date. In those cases, consumer cannot be made wait for indefinitely period. So like in this case, the commission held that 3 years time for this kind of project is a valid time for the possession. Now as already 6 years has passed to that, that's a double time, you are required to make the refund of the payment along with the interest. So in such cases where your agreement for sale does not contain any possession timeline and you want to file a complaint, you can rely on this judgment and can get your matter adjudicated. RERA has, by relying upon this judgment, has passed many such orders. This is one of such similar matter only, wherein the promoter has not executed agreement for sale and also the date of possession was not agreed upon. Then RERA ordered that as there is a considerable time of 6 to 7 years has already been passed to this project and this project is not completed, the promoter is required to refund this matter. The promoter is required to refund the amounts paid along with the interest of a 9%, and apart from that also awarded the legal cost of 25,000 to the allottee. This is also one of such matter where already the promoter had executed a sale deed, but the project was not completed in a duly agreed timeline. In that case, the RERA authority ordered the promoter to cancel the sale deed, bear all the stamp duty and other expenses, and as the home buyer had paid the interest at the rate of 13.75% per annum on their home loan, the RERA authority directed the promoter to make the payment of interest at the same rate. In this case, the promoter had charged some cancellation charges and paid the refund of the differential amounts. However, the complainant filed a case stating that there was no cancellation charges agreed upon in our terms. Still, the RERA ordered that cancellation charges up to 10% are allowed, and hence the complaint was dismissed. In this case of a Pitrai developers, the promoter had shown many amenities into the brochure but had not provided them on the site. The builder argued that we had already provided many other facilities which we have not mentioned in the brochure, but we have not charged for that. And there are many amenities which has been shown in the brochure, but instead of that we have provided many other amenities which are priority and necessity and on the request of the society, and hence this complaint should not be considered. The RERA authority held that brochure is clearly covered under the definition of the advertisement, and it is a legal paper under section 12 of the Act, and hence Pitrai developer is required to provide all the amenities and facilities as covered into the brochure within a 3 month of timeline to the society members. In this particular case, a single allottee had filed a complaint before the RERA authority and claimed the compensation amount for that missing deficient amount of common facilities. The RERA authority held that the common area belongs to the association of allottees, and hence an individual allottee cannot file a complaint for claiming a lump sum amount for that amenity. A society as a whole can claim a compensation for the common area maintenance and management, and an individual unit holder cannot. However, if there is an issue pertains to his particular individual unit, then he individually required to claim the compensation. But as this complaint pertains to common area and common amenities, the society as a whole can only file a complaint and not an individual complainant. In this particular case against the WTC, the RERA ordered the WTC to refund all the amounts paid along with the interest, and also apart from that ordered to pay the assured returns as per the agreed terms of the agreement to the unit holder. So these are some precedent judgments which has been relied upon and decided by the RERA authority on time to time basis. So once your order is passed and let's say RERA has ordered some refund with the interest, but the promoter is not paying you the same, or RERA has ordered the promoter to complete the construction or to provide some amenities not provided within a certain timeline, but the promoter does not provide it the same within that timeline, then you can very well file an execution petition. The format of the same is already prescribed. Just by paying a 500 rupees and making application in that order, you can in that format you can file a execution proceeding before the RERA authority itself, and in that you can claim even delivery of any property or attachment or sale of any property of the promoter, or arrest or detention of that person, or by appointing a receiver or any other remedy by which your grievance will get redressed. So this is basically the whole framework under which the RERA authority operates, and contains the precedent judgments and the scenarios in which the litigations are taken care by. Now, appellate tribunal is a multi-bench forum where under appellate tribunal there is a retired high court judge who chairs the bench, and then two other members, which are a retired civil court judge and one forest department retired person. So once your matter gets decided, you can move to appellate tribunal and then high court and supreme court. That's how this whole grievance redressal mechanism works. So this is from my side. If any question answered or any doubts anyone have, we can move to that.
Any question from anybody? All right, I think we can wrap it up. Lokesh bhai, if you can mute yours, I think voice is echoing. Yep. So thank you so much, Lokesh, for your insightful session, and thanks to the wonderful